All rise. The Honorable, the presiding Chief Judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Thank you, Mr. McFarland. Good morning. Welcome to your North Carolina Court of Appeals. My name is Chris Still, and I'll be presiding today. To my right, to my left is Judge Chris Freeman. To my right is Judge Julie Flood. We have one case on the calendar. The case is Kimberly Dunckel versus the City of Winston-Salem. And if you're ready to proceed, you can approach and let me know if you want to reserve any time for rebuttal.
Yes, I'm going to reserve 10 minutes for rebuttal.
Okay.
Good morning. May it please the court. My name is Caroline Grace Brothers, and I represent appellants Kimberly Dunckel and Fairytale Farm Animal Sanctuary. For over a year and a half, Kimberly Dunckel and her family used their over 3-acre property to run Fairytale Farm, a nonprofit animal sanctuary that took in farm animals with special needs and hosted small groups of volunteers, educational enrichment with Girl Scouts and homeschoolers, and occasional fundraising events. Neither the visitors nor the animals caused any traffic, noise, or odor issues in the neighborhood. In fact, the sanctuary's neighbors were supportive of the sanctuary, and it fit right into their rural-feeling neighborhood. Many of the homes have multi-acre lots and with farm animals visible from the road, and other businesses in the same zoning district, such as schools, churches, golf courses, daycares, are allowed to host as many, if not more, guests in the sanctuary. Despite all of that, the City of Winston-Salem decided that the sanctuary was a banned use in the Dunckel's RS9 zoning district. And under the tests enunciated by the Ace Speedway case, the city has the burden to identify the purpose behind shutting down Fairytale Farm, and then we get to provide evidence showing that prohibiting Fairytale Farm is not reasonably necessary to accomplish that purpose.
Is it allowed somewhere in the city? Like, where do they argue that it was allowed? What zoning districts? Is it allowed in some zoning districts?
It is, Your Honor. So the city has said that the sanctuary is prohibited because the closest existing use in the zoning code is an animal shelter, and animal shelters are permitted in commercial zoning districts.
How was the Fairytale Farm sanctuary directly and adversely affected? How would you answer that?
It's been directly and adversely affected by the city's prohibition because the city has ordered it to shut down. Under the city's interpretation of its zoning code, anything, the animals are not allowed if they're associated with the nonprofit, and neither are the visitors, even though the animals are allowed under the city's municipal code. The city allows other businesses to welcome guests as well in the same residential neighborhood. So the direct and adverse harm, Your Honor, is the fact that they are not allowed to run the sanctuary on their property, even though that is, the animals are otherwise allowed under city law.
What would you say that direct and adversely affected means in our jurisprudence? What would that mean?
I'm sorry?
In our jurisprudence, how would you define directly and adversely affected as it relates to this case? Yes.
I think it's the inability, Your Honor, to use your property in the way that you want, and it's the inability to run a lawful business, which is North Carolinians' right under the Fruits of Their Own Labor Clause and the Law of the Land Clause. And the city's prohibition on Fairytale Farm operating in the Dunckel's property certainly is an infringement of that right.
One more interruption. What decision did the city make that caused this? What would you say was the decision that they made that was the direct impact on the farm?
The decision was telling Kimberly that she could not run the animal sanctuary on her property. The city has been 100% clear from the beginning of this case that an animal sanctuary is prohibited on their property, and the Fairytale Farm specifically is prohibited. That's never been in question.
Did they try for any type of change to the text, any textual change, any going before some sort of administrative type of hearing to try to get anything changed?
They did not, because that would be, they were told by the city that would be futile, Your Honor. They're not permitted to seek a variance for a use that's not permitted. They cannot, the city told them that rezoning was not an option and neither was amending the UDO. And more broadly, Your Honor, seeking that type of administrative remedy isn't required before bringing a constitutional claim like this.
And you consider your claim facial versus as applied?
No, Your Honor, we consider it
As
as applied.
applied, thank you.
And what you're stating, you talking about the emails that were back and forth, that's when they were told these things, is that what you're saying?
Yes, there were the emails as well as in-person statements, Your Honor, and that's carried through all the way to discovery, where the city's 30B6 witness testified the exact same thing that the Dunkels were told at the time of enforcement, that the animal sanctuary is prohibited, and that is because the closest existing use is an animal shelter, and that is prohibited in their residential district. But yes, does that answer your question?
I think so.
Okay.
For now.
Okay. I want to be clear that the animals, the city's not objecting to the Dunkels animals. Those are perfectly allowed under the municipal code. And it doesn't object to them hosting personal guests. If Kim was a Girl Scout troop leader, she could host the Girl Scouts at her home without an issue. But it does object to them covering the cost of the animals using a nonprofit. And that's what makes Fairy Tale Farm a prohibited use. But that is exactly what North Carolina's Constitution protects. Kimberly's ability to earn money so that she can do the thing that she feels called to do. Take care of these animals.
But can't she do it? She just can't do it there. You can make that argument at anyhow. I mean, I'm just looking at the Chapel Hill UDO, and it says you cannot operate an automated teller machine, walk-up teller machine in your front yard, if it's residential, and that probably has very little traffic. But that's my business. I can't do it on that property. I can do it somewhere else. So how would you answer that? That she's not being prohibited. She just can't do it there, and you could say that with anybody's house.
So the fruits of the right to run a lawful business doesn't just protect your business being shut down completely. It also protects, we know from the North Carolina Bar and Tavern case, that it protects your right from.
Well, she could operate her business. She just has to go find a site that's in a proper zoned area. Just like if I want to have an automated teller machine, I'd have to go find a commercial site and put it there. So I mean, how's this different? Why can't the city say you can't do this in a residential neighborhood because we want to keep the residential character of the neighborhood?
So I think the city can say generally that it doesn't make sense to keep an animal shelter in a residential neighborhood. That's why we're not bringing a facial claim in this case. We're not saying that it should be allowed at every residential property in RS9.
So you're saying it's not an animal shelter, so that's part of your argument too.
No, we accept that the animal shelter is the closest existing use in the UDO, but we're saying that prohibition as applied to these facts, as applied to the sanctuary, is unreasonable. Because under the reasonably necessary test, the city has to show that it has a proper purpose, and then we get to provide evidence that the means it chose to accomplish that purpose, prohibiting Fairy Tale Farm, is reasonably necessary to accomplish its goal, which is preventing traffic.
So it could prevent other animal shelters from operating. It could prevent animal shelters generally. So what is different about your client's business than a normal animal shelter? You keep animals, people come visit. What's different that makes y'all being treated differently? If it's an animal shelter, and you can prohibit it, so why is this different?
It's different, Your Honor, because A, the animals are permitted under the city's municipal code.
As they would be for an animal shelter, but you've already conceded that an animal shelter, they can prohibit that in a residential neighborhood if it's an animal shelter. So what makes yours different than a normal animal shelter that your argument could be prohibited?
Right. We're a much lower impact use, Your Honor, than an animal shelter. So an animal shelter in the zoning code is designated a high impact use, and the Fairy Tale Farm is much more similar to a home daycare, which is a low impact use, because a home daycare is permitted to take care of up to 15 kids at a time, not including staff. And the sanctuary here is only asking to be able to host 10 volunteers at a time, or events with up to 20 event attendees. And the city's 30B6 witness testified that there is no difference in terms of impact between 15 children visiting a daycare, which is allowed, and 15 children, Girl Scouts, homeschoolers visiting the sanctuary. As to the purpose for prohibiting Fairy Tale Farm, which is preventing traffic and noise and other negative impacts, those two uses are on the same footing.
Well, if I have a walk-up teller machine in my yard, I don't think more than one person would walk up at any any hour, but I mean, I can't do that. And I think the city can tell me I can't do that in a residential neighborhood. I'm trying to understand, but an animal shelter could have like 5 animals. It could be small, but it's prohibited, and they could prohibit that.
If the city's reason for prohibiting an animal shelter is preventing traffic, noise, and odor, the Constitution requires its prohibition to be reasonably necessary to accomplish that goal. So if there's evidence, as there is here, that prohibiting the sanctuary doesn't actually prevent the harms that the city says is trying to prevent by prohibiting the fairy tale farm, then it is unconstitutional. And I want to say that the record is absolutely clear that Fairy Tale Farm did not create any traffic, noise, or odor. So the city's 30B6 witness testified that the city is not aware of any negative impacts caused by either the sanctuary's volunteers or its visitors, admitted that there's no difference in impact to the neighborhood between animals that are associated with the sanctuary, which are illegal, and animals that are not, which are legal.
Isn't it true that the city didn't have such a problem with them having the animals in the sanctuary? It was just the appearance on the outside looking in of a business, and they wanted that to be corrected. Is that not correct?
So under the way that the city has explained it to us, it's anything that the Dunkels do that's associated with like the use is actually prohibited. Even the animals would be prohibited if they are associated with the sanctuary, paid for using donated funds. And
did the Dunkels voluntarily stop having the animal shelter? Or did somebody directly come in and make them do it or tell them to do it?
The city came in and ordered them to shut it down.
Where is that order at?
That the city came in and visited them in January of 2023.
The record?
Yeah, that is in the record. I don't have it directly in front of me, Your Honor, but I will find it and provide it on rebuttal. But it was the city came and visited them in January 2023, and then it sent subsequent emails ordering her to shut down.
If there's a direct order, I'd like to see it. Thank you.
Of course. So I think we've talked about that the city is unaware of any negative impacts caused by the sanctuary's volunteers or events. And as I mentioned, it fit right into the neighborhood. None of their neighbors ever complained. Many actively supported the sanctuary by volunteering or donating. And even the across the street neighbor from the Dunkels testified that the sanctuary did not cause traffic, noise, or odor. And that makes sense because we're talking about a property that's 3.3 acres. All of the animals are in the backyard. It's not visible from the road. The parking lot can fit up to 10 cars easily. And it fits right into the neighborhood that it already has rural feeling, multi-acre lots with farm animals visible from the road. And the cherry on top here is that the city allows other businesses in the same residential district to host the same number, if not more, guests than the sanctuary. So again, the Dunkels want to host no more than 10 volunteers or 20 event attendees, but home daycares are allowed to host 15 children, golf courses, schools, churches, recreational facilities, libraries are all allowed to operate in RS9 and host as many, if not more, visitors.
Well, could the city prevent me from operating a law firm out of my house where I'll have no more than 2 people show up? Can't they do that? Can't they say you can't operate a law firm in your, or a dentist office or whatever, in your house in a residential area, even though I may only have 2 patients at any one time, but I can host a daycare that has 10 kids at a time? I mean, can't cities do that if they want to?
So I think it would depend on the purpose the city had behind prohibiting the law firm, Your Honor.
Keep the residential character of the neighborhood, and so they've made the policy decision that daycares are okay, but not animal sanctuaries. I mean, can they do that, or is that too arbitrary? I mean, is it arbitrary to say that I can't have a dentist office that only has 2 patients? I mean, where's the line, I guess, is what I'm trying to figure out.
So I would point out, Your Honor, that the city also allows golf courses and recreational facilities in the same residential district. So we're not only talking about home daycares and schools, but even if the zoning code were.
Then what's wrong with animal shelters? If they have, why is it okay for them to not allow animal shelters, but they can have golf courses? I mean, aren't those just sort of policy decisions that the city makes, or is it too arbitrary?
It is, in general, as I said, it is in general a decision that the city can make, but that doesn't mean that someone can't come into court and say, as applied to me, this prohibition violates the Constitution. And here, the fact that the city allows these other uses to operate and pose the same risks to the residential neighborhood is the same fact that was fatal to the state's abatement order in the Ace Speedway case. So there, the state closed down Ace Speedway to prevent the spread of COVID-19, but allowed other racetracks and event venues to operate and pose the exact same risk. And here, the city shut down Fairy Tale Farm in the name of preventing negative impacts like traffic, noise, and odor, but it allows other businesses to operate and pose those same risks. And as the court said in Ace Speedway, that is a particularly ineffective means of achieving the city's goal while imposing a tremendous burden on Fairy Tale Farm.
Should the fact that the ordinance existed prior to, it was not something that came after the fact. So prior to the appellant even beginning this sanctuary, how does that factor into our evaluation?
So I think that kind of consideration would only come in at prong one of the reasonably necessary test, whether the government had a proper purpose in enforcing against the sanctuary. I don't think it factors into prong two, which is whether the means chosen by the government is reasonably necessary to accomplish its goal.
Because I'm guessing that maybe the churches that came in or some of these other permitted uses, maybe they asked on the forefront. I mean, it's not something that we have before us, but I'm kind of bothered by the fact that this happened after the fact.
That the enforcement occurred after the fact, Your Honor?
Without them having applied apparently for any type of textual change prior to opening, just sort of opening against the way that the code read, and then after the fact trying to then complain about it.
I see, Your Honor. Well, so when they opened the animal sanctuary, they believed that they were falling under an exemption for bona fide farms. And so they thought that they were in complete compliance with the code, Your Honor. It was only after the city enforced that the Dunkels found out that, in fact, the bona fide farm exemption is only an exemption for county zoning requirements and not the city. So that they believed themselves to be in compliance the entire time. I want to talk about the equal protection claim. The government violates the right to equal protection when it treats similarly situated people or activities differently without a rational basis. And here, the city's goal in preventing Fairy Tale Farm, or in prohibiting it, is preventing traffic issues in their zoning district. But again, other uses are permitted in RS9 that create similar impacts. Home daycares, as I've said before, are allowed to care for 15 children a day. Golf courses, churches, schools, libraries, all allowed to host many more guests. And that difference in treatment is arbitrary. The city's 30v6 witness testified, again, that there's no difference in terms of impact between 15 kids visiting a home daycare and 15 kids visiting an animal sanctuary. So there's no rational basis that justifies barring the sanctuary's guests alone. And as for the animals, Winston-Salem is permitted by, or any citizen in Winston-Salem is permitted by city law to keep those.
What would be the rational basis for the city prohibiting me from running a dental office out of my house if my evidence showed that I only have 2 patients here to visit at a time? You're allowing daycares, but or are you saying that the city cannot prohibit me from having a dental office or anything else that has less than 15 people that show up at any particular time?
Well,
that all those ordinances are out.
Again, Your Honor, I think it would depend on the purpose that the city gave for prohibiting a dental office. I think the city could theoretically have more justifications for prohibiting a medical office in a residential home, but here the only purpose that the city has given is preventing traffic, noise, and odor, and so that's what the inquiry here has to focus on. The city's only argument against the plaintiff's equal protection claim is that Fairy Tale Farm isn't similarly situated to these other uses that I've mentioned. And that argument fails. The city has said that Fairy Tale Farm is different because they don't need to follow the same permitting and licensing requirements, and these other uses are more necessary than the sanctuary. But that misunderstands the similarly situated analysis. It doesn't require uses to be identical. It just requires them to be similar with respect to the government's goal, which here is, again, preventing traffic and other negative impacts. And an almost identical argument was rejected in a case cited in our brief, the Catherine H. Barber Memorial Shelter versus Town of North Wilkesboro case. That's at page 28 of our brief. There, the court held that the town had violated a homeless shelter's right to equal protection by requiring the shelter to obtain a conditional use permit, but not other uses such as nursing homes and emergency shelters. And as in this case, the town there argued that other uses were not similarly situated because they needed to obtain permits and operated for different reasons. But the court tied the analysis directly to the city's purpose, and it said that there, the town's reason for requiring the permit was the intensity of the land use, and neither the permitting process nor the reason a use operates has anything to do with the intensity of the use. And the same reasoning applies here. The city's goal in prohibiting Fairy Tale Farm is preventing traffic issues, and neither of the city's alleged differences has anything to do with preventing traffic.
And you're eating into your 10
Yes,
minutes.
yes. So the city is treating Fairy Tale Farm differently from similarly situated businesses with no rational reason for doing so in violation of the Equal Protection Clause. I'll reserve the remainder of my time.
Thank you. We'll hear from the appellee.
Good morning. Marissa West with the City of Winston-Salem. And I am representing all of the defendants in this case. This case is a zoning case, and what it has to deal with is the City of Winston-Salem, along with the Forsyth County, we have a joint UDO, Uniform Development Ordinance, that was passed prior to Fairy Tale Farm's opening in our jurisdiction. The UDO is a comprehensive plan that is authorized by the North Carolina statutes. It sets out the commercial areas, the residential areas, the commercial areas, the agricultural areas in the city and the county. The piece of land that we're talking about today is RS9. It's a single-family zoned residential area, which allows the minimum square footage in an RS9 is 9,000 square feet, so 0.2 acres. Now it happens that the Dunkel's lot is larger than that because it's several pieces of land that lots together. What happened in this case is our zoning enforcement received a complaint. They went out. They saw that Fairy Tale Farms was operating in the city, and they weren't just operating a small-scale nonprofit business. They were operating a pretty large nonprofit business in our city. They were more or less a regional attraction. They had events where hundreds of people came. As you can see by their own affidavit, I think they have an affidavit from one of their neighbors, due to all of the traffic they would have and all of the people who would attend their events, that you had to use her big blank lot for parking.
Let me ask you a question. You've argued in your brief that they don't have standing. Do you argue they don't have standing to at least bring this action?
Yes, that is in our brief, that per 160D 1403.1, that statute says that in order to have standing, there has to be a final and binding decision. There has not been a final and binding decision. What happened is the zoning enforcement went out there, they saw what was going on, they looked at their website, saw all of their events that they had listed, all the time slots. They sell pumpkins at Halloween, Christmas trees at Christmas, their full-scale operation, said, hey, y'all are in an RS9 zoning area, it's single family, you can't operate this business out of this lot.
I'm going to read just an excerpt from a Supreme Court opinion from 1987. It said, in order to challenge the constitutionality of an ordinance, a litigant must produce evidence that he has sustained an injury or in immediate danger of sustaining an injury. And in that case, it said appellant's complaint, which was a church, contains an allegation that the city intends to require it to pave its parking lot. There was no final decision. This complaint does not in of itself confer standing. However, the defendant's answer prays that the church be ordered to immediately cease use of the property until they are in compliance with the ordinance. And I'm just reading one of your answers. You said you admit that y'all told Ms. Dunckel that she could not host events or she would be fined, she would be issued a notice of violation. So doesn't your answer confer standing based on the Supreme Court case? Even though there might not be a final decision, you've admitted in your answer that you say she's in violation and you're gonna do a notice of violation in your answer. How's that any different than this Grace Baptist Church in this 1987 case that I think y'all cited or was cited in some of the briefs?
Well, I think when that case came down, 160D 1403.1 was not a North Carolina statute that required a final and binding decision.
But doesn't that section also say this does not limit other rights of action that might exist as a matter of law? I think there's maybe 160B, I can't remember if there's another provision in there.
How do you read subsection 160D 1404 to apply to the DGA? I think
That's the one. That's the one. Yeah.
How would you answer that?
This, except as otherwise expressly stated, this article does not limit the availability of other civil actions otherwise authorized by law. And our Supreme Court said that you have standing to bring a declaratory judgment action, I guess, to challenge the constitutionality of ordinance. If y'all said in your answer that you basically admitted that they are in violation and you intend to cite them if they continue doing it. Because I think what we're saying is 160D is not exclusive, because you do have this 160D-14-1404, which says that this doesn't limit the availability of other civil actions. And so they're claiming they're bringing this under the declaratory judgment action.
1404 says it doesn't limit other actions, but 16D 1403.1 specifically deals with declaratory judgment, injunctive relief actions. It says it's not going to ban other civil actions, but 1403.1 says you have to meet the standing requirements in order to bring a declaratory judgment action.
On the standing issue, would you say that the emails back and forth between the city and the Dunkels were an administrative action?
I would say they were done by our administrative staff. Our staff went out there and said, hey, you can't operate this, you need to stop. And then the Dunkels stopped hosting events and operating the sanctuary out of the property. And then we closed our case, but we never issued a notice of violation.
When counsel stated earlier that there was in the record something from the city stating they had to shut down, are you familiar with that?
There was never an order, and there was never a notice of violation issued. That would have been the next step. Would have been a notice of violation, but there was never a notice of violation. Our zoning officers went out to the property, saw the commercial use of the property, and said, you can't operate. And then at that point is when they stopped having the events at that location. I think they still have events at other locations, but they stopped having events at that location.
Are you saying that without that notice of violation, it falls short of being an action?
Of a final and binding order.
And that you're saying that's what it requires to rise to the level of a state action? That's what
160D 1403.1 states.
Would you, if they get a notice of violation, is there a fine that accompanies that?
If they don't comply with the notice of violation, yes, there can be a fine.
So if they went out and operated right now, could you fine them, or you can't fine them?
We would have to issue the notice of violation first.
And how much time would they have to comply?
I am not exactly sure. I think it's between 5 and 10 days.
But you could not find them right away. Is that what you're saying?
No, I could not because there has not been a notice of violation issued. You have to give them notice first.
So if I wanted to, let's say I wanted to spend a bunch of money on my property to build an animal sanctuary, and it's going to cost me $100,000, and I come to y'all and say, I'd like to do this, and you're like, no, you can't do it. Do I have to spend the $100,000 to do it to get the notice of violation before I have a final decision to challenge your advice to me that I can't do it? What other, do I have to spend that money to do it, or is there any other way that I can get into the courts to say that you're violating my constitutional rights?
Well, it would be dependent on why the city told you no. Is it in the wrong zoning? Can you file a motion
Let's say it's
to
the
rezone?
reason she had. Let's say they have not built it yet, but we're going to spend this $100,000 on our 3 acres of land, and you come out, you can't do this. And so, can they bring it to court? Because you've basically said we will issue a notice of violation if you do this. Do they have to spend $100,000 to get their stuff up and running before they can get to the court system? Because you're not going to issue a notice of violation until they violate, and they have to violate to get in the court system.
No, you don't have to violate it. No, they can file a motion to rezone. Say their
No, they think they're allowed to do it. We're like, we think we can do this here, and your guys come out there and say, you cannot do this here, but you don't issue a notice of violation because they're not currently in violation. How can they get into the court system to say, you're wrong, you're violating our constitutional rights? We want to be able to do this use here, but they're not currently in violation, but they have to spend $100,000 to become in violation to be able to get in the court system. Because you basically, I mean, how can they challenge this ordinance without spending a bunch of money and actually committing the thing that you said is a violation? Let's say they had not operated their animal sanctuary at all. We want to do this on our property, and you come out and tell them you can't do this, and they don't agree with you. They think they should be able to do it. How do they get, and what do they do? Because there's no notice of violation to be entered because they're not in violation yet. They need to spend their $100,000 to build all their shelter stuff that they want to do, and they're going to have to waste all this money before they get to the court system. That's why I'm trying to understand how else did they get here?
Not knowing all the details of the hypothetical, I mean, they might be able to fashion a quorum claim if they meet the elements for that. I'm not certain of all the facts.
Okay, I'm just trying to understand, because you're saying they can only get here if they get a notice of violation. That's what gives them standing. So they would have to spend the money to go into violation. If they're saying we're planning to do this out here, but they're not in violation, so there's nothing for y'all to enter. So they could never get to the court system. They would never have standing until they actually spent the money to violate, which y'all would say is a violation. That's my question.
I mean, they could possibly get there through quorum if they meet the criteria for that, for a quorum claim.
So what they would need to do now is to open up to begin again what they were doing so they could get their notice of violation to get to court. I mean, that's what they voluntarily closed down, so they need to start back up again if they want to get to court, is what you're saying. So you will issue them a notice, because they're not in violation right now. So they need to spend the money to have more shows or have people come out there, so y'all will issue the notice of violation. Even though you've said you will issue the notice of violation if they do it. I'm just trying to understand the standing issue.
I mean, they could possibly have standing under a quorum claim, which is separate from the 160D 1403.
Okay. That's all I had about the standing.
Okay. The city of Winston-Salem has a proper government purpose, as is needed and listed in the cases. Our proper government purpose is preserving the neighborhood character, the safety, intensity of use of residential areas. It includes things like traffic, odor, noise, but traffic is not the only purpose of the city of Winston-Salem for Cy County UDO. So the proper government purpose is the neighborhood character, safety, intensity, and use. And as it's stated in the case laws such as Kinsley versus a Speedway Racing, the first step in the inquiry is the court is looking for the state's actual purpose. What's our actual purpose? And the first initial step in that is us putting forth, asserting our purpose. And then the next step is the plaintiff may rebut that assertion with evidence demonstrating that the state's asserted purpose is not the true one.
So what's your purpose? What was your stated purpose?
The purpose is to protect the neighborhood character, the safety, and the intensity of use for residential neighborhoods, so people can live in quiet neighborhoods.
Well, how would you answer them that, well, we're being treated different? Like in Ace Speedway, I guess these people were allowed to do their speedways, but Ace wasn't, even though they're probably similarly zoned. But they're saying here you got these uses that are much more burdensome or louder, or you have a bunch of kids coming over. Why is this different?
Well,
how is this different than Ace Speedway, where you're treating these people differently than you would treat somebody that wants to operate a daycare?
so for the equal protection component, and in Ace Speedway, it had to deal with the government came out and said, hey, our purpose is to prevent the spread of COVID. And Ace Speedway came out and they gave a different purpose. They said, the purpose of the state is not to stop the spread of COVID because they only enforced it against us. It's because I spoke out against the governor and his policies and I was critical of it, and that's why they targeted us. And it was a 12B6, so.
Well, you're saying the purpose is that we don't want a lot of traffic out there, and they're saying you don't like animals. You're okay with kids, but not animals, I guess. And so your purpose really isn't real because you're allowing all these other uses that have a lot of traffic out there.
Traffic isn't the only thing. It's to protect the sanctity of the neighborhood. And there are certain things that people need in their neighborhood. The things that we protect are the safety and the health and morals and the general welfare of the neighborhood. And for that, neighborhoods need schools for education. They need churches for worship and spiritual well-being. These things are always allowed in residential districts in any UDO. Recreation for health. The parks are allowed in neighborhoods, small recreation areas. Those are things that people need for their daily lives, along with daycares. People have to have daycares so they can go to work.
Is there anything in there that limits the number of pets I can have in that neighborhood?
No. The city of Winston-Salem ordinances, let me back up. The city of Winston-Salem ordinances for animals do not limit most pets. Though there's some animals that are not allowed in the neighborhood, like pigs that I think Ms. Dunckel had at one point, but I don't think she has any longer. Those are not allowed in the city. The city has a limit on rabbits. You can't have more than 10 rabbits. I don't know how many, if she has rabbits there currently or not, or how many she has. But it does not have limits on the majority of animals it's allowed. So there's some animals that aren't allowed under the policy and some that are. And it does have, different requirements just for.
So she could have pets, but she
Space.
can't have an animal sanctuary. So what's different about an animal sanctuary than just saying these are my pets? As far as the use.
Having events with, I think one event they had about 400 people out there at a time. And it was, if you look at the brief and look through all the events they had, Halloween events where people would sign up for different times. And it's not just people from the neighborhood coming over to, see the animals or something like that. It was a regional attraction where people would come from all over to sign up for events. And then countless groups. They even had glamping where people could camp on the property.
So could it still be operated as a 501c3 and get, say, quiet donations rather than donations reliant upon activities versus pets?
When the zoning officers went out, that's what the zoning officers talked to them about, doing a home occupation, which they could apply for to get a home occupation license to run just the 501c3 through the website and get their donations and everything as a home business. That's never been applied for, but they were given that information.
But just not the events there. They can't have the events there, is what you're saying. What places could, what zoning, where could they have it in Winston-Salem? There are districts where they could do this.
Yes, animal shelters are allowed in commercial zonings. They could, in the county, there's agricultural zonings where they could have a bona fide farm. So they do have options, but it's just not an RS9 residential district.
Isn't it true that it wasn't any of these events or anything that had an adverse effect on the neighborhood or preserving the neighborhood that brought your attention to the Dunkels? It was maybe a malnourished animal somebody had seen or something like that. Not any complaints about the 400 people, anything like that. Is that correct?
We're complaint-based. We received a complaint, and the complaint also had about the visiting public in there. And so when that complaint was received by the city, that's when the city went out. And there was another complaint received after that, but I think that had to do with animal safety.
And in the emails back and forth, is it not true that you were given options to them about what they may be able to do to become in compliance? Not shutting them down, but giving them options that they could potentially look into?
Yes, if they were given they were asked, hey, are these your pets? If they're your pets, you can have them. And as long as you're not operating a commercial business out of here, and you tell us they're your personal pets, then we're good. And that's what happened. They said, these are our personal pets. We're not going to have any more events. We're not having everybody over. We're not going to advertise these large-scale, events anymore.
And what point did they
And
shut
so
down?
we
Was
shut
it because,
down our case.
what point did they shut down the farm? Was it because you told them to, or because they just chose to?
I believe they shut it down because we told them they couldn't have their events there, and I think they have events elsewhere now.
Did you specifically say shut down Fairy Tale Farms? Did the city say that?
The city said that you can't operate this commercial venue in a RS9 district, yes.
But that wasn't final and binding.
I'm sorry?
But that wasn't a final and binding decision.
No. And so going back to the A Speedway, and a lot of these cases, what happened in those cases is the government put forth what their purpose was, and then the plaintiffs put forth and said, that's what they're saying their purpose is, but we have evidence or we believe that their purpose is something different. That's something that hasn't happened in this case. Fairy Tale Farms or the plaintiffs have never put forth an alternative purpose. So under the analysis in Kinsley Speedway, there hasn't been any challenge to what our purpose is, which is preserving residential neighborhoods so they can be quiet and safe, so there's not people coming from across the region to go to events in somebody's neighborhood. With that said, our means chosen to do this is in order to preserve the sanctity of the residential areas and have the commercial areas and everything else in the city and the county. The city-county passed a comprehensive UDO per the statute that sets up these districts within the city and the county. And in that, it allows uses that are needed for the health, safety, and well-being of the people.
What makes something an event? Like if I owned 3 acres in a residential neighborhood and I just want to have a big Super Bowl party and I invited 300 of my closest friends, can I do that? I mean, or what makes it an event that makes it like you can't do that in my residential neighborhood? Because I could have a big Super Bowl, I could imagine, or a big Halloween party. And by the way, I have pets here if you want to look at them. But I mean, what makes an event? Is it the fact that it's just kind of open to the whole public, and I don't have a guest list, or what am I allowed to do? What makes this an event that makes it bad rather than just like a Super Bowl party?
Well, with the Super Bowl party, number one, that's once a year, and I don't.
Well, I'm gonna have a Halloween party too. I'm gonna have 6 parties, whatever. But I mean, I can have parties in my house. So what makes this event different than just having at my house, and I have, you can look at my pets too if you want to, whatever, I don't care, but what makes this different? Because you say they can't have events. So what makes this an event that makes it bad where other events in a residential neighborhood, like a big Super Bowl party, are okay?
Events being the commercial nature of it. It's that they're part of a business, that you're charging fees,
Okay.
and and the frequency, and that they're part of a business. It's a commercial business that's happening in violation of the RS9 zoning district. And with RS9 residential district allowing a minimum of 9,000 square feet, which is 0.2 acres, we can allow animal sanctuaries on all the RS9 lots in the city. And frankly, if the city allowed it on one RS9 lot and then treated all the other RS9 lots differently, that's when we'd be opening up ourselves to an equal protection claim. We can't treat one RS9 lot differently from all the other RS9 lots in the city.
And you allow schools within those areas. What's the differentiation where this is educating the public through different gatherings, and I think you said homeschools, scouting, educating the public about the plight of the animals? Why would this not equate with some sort of educational opportunity as well?
I think the sanctuary could be an educational opportunity. It just can't operate in an RS9. Schools are different because it's mandatory that children have some kind of education, whether they actually go to a physical school or they do homeschool or what, and people need to be able to access those schools.
But they can be for-profit schools, is that correct?
Yes, there can be private schools. And I don't know if there's any private schools operating within the RS9 district, but I would have to look at the requirements for that. But the difference is schools are necessary. People have to go to school. It's for the health and the well-being of the community. And it's also regulated. It's also statutorily regulated where schools can be and where you can zone them out of and not zone them out of, on top of that. But it's a legislative decision of these are the things that we feel fits into the residential character of a neighborhood. And these are the things that we think fit with the health and well-being and the welfare of a neighborhood, that they need to have these things close by, and that's going to be beneficial. Whereas an animal sanctuary, I think it can be educational. I just don't think it needs to be in I don't think it needs to be in a residential district. It's not a church or a school or parks or something that's the legislature has decided that these things need to be close by, because if people don't have transportation so they can get to a park, if they aren't able to get 30 minutes down the road to a school if you put them all in commercial districts. It's things that fit in line with the purpose, and the purpose is listed in 160D 701, the zoning statute, for the legislature to pass. So the things that are allowed are the things that people need for their health and well-being and all of the purposes. And I will say on that, just with the similarly situated, I know the plaintiffs have taken a very broad view and said they're similarly situated to anything that creates traffic. With that same argument, you could say, well, I'm going to open up a coffee shop out of my kitchen and I'm going to sell coffee. And I mean, I have some traffic, but my neighbors all come over and get coffee, so that's okay for me to have, this coffee shop here. All of the cases that deal with equal protection claims and similarly situated, none of them have found that broad level. For example, a case that the plaintiffs cite to, the Proctor versus City of Jacksonville, and it's the food truck case where the zoning ordinance passed for food trucks was quite restrictive and only allowed for certain places. And in that case, the court found, hey, we're going to find you're similarly situated to other businesses that sell food and drink. They didn't say, hey, well, you're going to be similarly situated to anything that creates traffic. In the other case that they cited to the Catherine H. Barber Memorial Shelter versus the town of Wilkesboro, which dealt with a homeless shelter. In that case, they didn't just say, hey, we're going to find you similarly situated to places that have overnight guests. We're going to find you similarly situated to places that have people overnight that are attending to a special need, like nursing homes, temporary shelters. That's what they found them to be similarly situated to. And in this case, when you look at that, the animal sanctuary is not similarly situated to the schools or the churches or the parks, the things that the legislature has said these things are what people need to be close to them so they can get to them if they don't have transportation. None of these cases took a broad view of similarly situated and said, well, anything that creates traffic, you can be, well, then you're going to be similarly situated to any kind of use. You could be a factory and have workers coming in and do traffic. The whole point of having zoning districts is, in having a comprehensive plan, is to be able to keep the unity of the city and keep, you know, the industry in one area and the commercials in one area and the residential in one area where people can live in a peaceful place and have the sanctity of their community, which is the whole point of having these zoning. And this wasn't a regulation that came down after they opened up their sanctuary and the city decided, oh, we're going to shut that down. We're going to pass something that says they can't have it here. This was in place when she purchased the property. This was in place when she decided to open up a sanctuary.
Thank you. We have a rebuttal.
So I want to start by addressing your question, Judge Freeman, about the places in the record where the city told Kim that she couldn't operate the animal sanctuary. So first, I would point you to Doc X 61, which is a case summary of the visits that the city zoning officers made to Kim's home, where they told her that she couldn't operate the sanctuary. Second is Doc X 63 through 65, which are the emails that those zoning officials told Kim that she had to stop operating the animal sanctuary. They specifically said the property is in the RS9 zoning district. You would not be able to run / operate an animal rescue / sanctuary. That's at Doc X 63. And then again at Doc X 202 and the 30B6 witness's personal testimony, he reaffirmed again that Ms. Dunckel cannot operate the animal sanctuary. And that kind of leads to what I wanted to mention regarding standing. Chapter 160D provides multiple avenues to challenge a zoning ordinance. Section 1401 allows plaintiffs to challenge the constitutionality of a zoning ordinance via the Declaratory Judgment Act, full stop. Section 1403, which is the section that the city was talking about, allows plaintiffs who've already received that decision to challenge the decision in court in lieu of appealing to the Board of Adjustment. So it allows you to skip that step under those circumstances, but it doesn't impose that requirement on all challenges to zoning ordinances. And we know that because in 2024, after Section 1403.1 was decided, this court decided the Proctor versus Jacksonville case, which was another case with a constitutional challenge to a zoning claim with no prior final decision. And no one saw any jurisdictional issue in that case because there isn't any, because plaintiffs are allowed to bring their claims under Section 1401. And the same is true here. Turning to the merits, the city said that its purpose is broader than traffic and noise because they're trying to preserve the neighborhood character, they're trying to protect the health and safety of the neighborhood. But the only way that the city has said that Fairy Tale Farm impacted health and safety, impacted the residential character of the neighborhood, is by creating traffic. So that's why we've been focusing on traffic here. And I want to address briefly, factually, the pigs are not allowed under the municipal code, but the Dunkels do not currently have pigs, and they do not plan to in the future. They've moved all of their rabbits to an off-site facility, so they are completely in compliance with the municipal code. And the city brought up the past events that the Dunkels conducted and said that those negatively impacted the neighborhood. But that's directly contradicted, again, by the city's own 30B6 witness, who testified that he was not aware of any negative impacts caused by the Dunkels events or their volunteers. But it's also immaterial because the Dunkels moving forward are limiting their visitors to 10 volunteers or 20 event attendees. So they're not going to be hosting the same types of events that they were before. And at one point, the city said that the Dunkels could just obtain a home occupation permit and run the sanctuary that way. But the city's 30B6 witness testified that because its zoning code prohibits exterior evidence of a home occupation, the Dunkels couldn't run Fairy Tale Farm from their home if they used the nonprofit to care for their animals, because the animals themselves would be illegal as exterior evidence of the home occupation.
I want to try to understand what's before us, because, I mean, Fairy Tale Farms did a lot of things, and it seems like they said that, well, they could do some of these things, but not these other things. What did the trial court order? That they can't do anything? Or, I mean, what are we being asked to decide that all or nothing, they can either operate their charity or whatever, or not do anything? Or are we being asked maybe that these things are okay, but these things aren't? I mean, what's before us?
So
I'm trying to understand what the trial court ruled. That's the order that's before us.
So the trial court's order didn't contain any reasoning. So
They granted summary judgment. So what were they seeking summary judgment for? What was their motion for summary judgment? What were they asking for that was granted? I guess that's the place to look.
Sure. So they were asking summary judgment to show that applying the animal shelter prohibition to Fairy Tale Farm was constitutional. And as the city's 30B6 witness testified, applying the animal shelter classification to the sanctuary means that none of the things that the Dunkels did that were associated with the sanctuary is legal in a residential district. That means the animals are illegal if they are paid for using donated funds, and that means the visitors are illegal if they are associated with the sanctuary. So it is all of it that the city is saying is prohibited.
I'm looking at your prayer for relief, and yes, declaratory judgment that the city's event ban on plaintiffs violates whatever. So we need to address each one of those, because I guess that's what they moved for summary judgment, that all these get thrown out.
Yes, Your Honor, and since the complaint was filed, at the time, the city had said that they were allowed to keep the animals but not have any visitors, but that has since been clarified by its 30B6 witness that, in fact, the animals are prohibited as well if they are associated with the sanctuary. And on the subject of the events, the city said that the reason that the events are not permitted is because they're part of a business, but that the right to run a lawful business is exactly what the Fruits of Their Own Labor Clause and the Law of the Land Clause protects. The ACE test requires regulations on that right to be reasonably necessary to accomplish their goal. And here, the city's prohibition fails that test. The city's argument, in essence, is we get to zone, period, and it doesn't matter if if our prohibition is actually tailored to the purpose as required by ACE. But to quote the North Carolina Bar and Tavern case that came out this past fall, the citizens of this state rejected "because I said so" governance years long ago. So here, the city's prohibition on Fairy Tale Farm fails the reasonably necessary test because it comes nowhere close to being reasonably necessary to prevent noise, traffic, and odor.
Just for clarity on
Yes.
something you just said, just so I'm not confused. With the exception of the rabbits and the pigs, is Fairy Tale Farm still in operation?
They still have the animals on their property, yes, but they are not hosting events or volunteers.
So, is it your contention that the city having an open investigation on a zoning issue confers standing to the Dunkels?
I think what confers standing is the fact that the Dunkels have been ordered to stop. It's not an open issue, Your Honor. They've been told in no uncertain terms that they cannot operate Fairy Tale Farm on their property. And that is enough. That is a direct infringement of the Dunkel's right to run a lawful business. So yes, that does confer standing.
That was through emails, not an official document or anything from the city, is that correct?
It was through their in-person visit, and it was through the emails that the city communicated to the Dunkels.
So they never received a sanction or anything from the city saying this is officially something from the city, you've got to stop now, or you got this sanction, you got this fine. It was just a warning, perhaps.
So I wouldn't phrase it as a warning, Your Honor, because the city was told that it was illegal and that they would be in violation of the zoning code if they continued. That's not just a warning. That's ordering them to shut it down. The section, just going back to the standing argument, section 1401 doesn't impose that requirement to obtain a final and binding decision before you can challenge the zoning ordinances under the Declaratory Judgment Act. You just need to have a specific and personal legal interest that is directly and adversely affected. And that's exactly what we have here.
I'll give you a minute to wrap up since you answered this question.
Okay.
If you need it.
Yeah. I'll just say that the fruits of their own labor clause and the law of the land clause protects Kimberly Dunkel's right to earn money and run her lawful business so that she can fulfill her vocation, her calling, which is taking care of these animals and serving her community. And because the record shows that prohibiting her from doing that is nowhere near reasonably necessary to accomplish the city's goal, the city violated her rights under those clauses. Thank you, Your Honors.
Thank you all for your excellent arguments. We'll take this under advisement and we will adjourn court.
All rise. This session of the North Carolina Court of Appeals is now adjourned.